Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
The ObamaCare lawsuit and our litigation will be decided in the next several weeks. I'll talk about it today on Faith and Freedom. I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Shawn Akers, the dean of the Helm School of Government at Liberty University. Shawn, yesterday we talked about the supplemental brief that Liberty Counsel filed on behalf of Liberty University and two private individuals, where we challenged both the individual and the employer mandate at the Fourth Circuit Court of Appeals in Richmond, having been the first one to argue the case at the United States Court of Appeals level. And we had to file a supplemental brief with regards to whether or not a federal law known as the Anti-Injunction Act actually applies, which we argue that it does not apply. The court can rule right now. We don't have to wait until 2014 when the mandates are in effect, because the mandates and the law are actually going into effect now. The federal government has also now agreed, amazingly, that the Anti-Injunction Act does not apply and that the court can and should reach the merits of this case.
You know, Matt, we were talking a little earlier, and that puts us in a very unique situation when you've got the United States government interpreting the statute, as you pointed out. For the court to decide anything different would definitely be an anomaly here. So the chips are definitely stacked in Liberty Counsel's favor, at least on that issue. You've been arguing the same argument since the beginning on this. It appears that it's just an unavoidable conclusion.
Let me talk just a little bit about why we believe it doesn't apply, and it's really confirmed, and I think the nail's in the coffin now with the government saying it doesn't apply. And then I want to talk about what I mentioned yesterday about some of the things I found that's in this bill, particularly with regards to a amicus brief that was filed by 350, I believe it was, Indian tribes. But it's an indication of what's in this bill lurking around that really, as Nancy Pelosi says, we'll have to pass the bill to find out what's in it. You know, I've been litigating this thing. I found out a brand new thing that's in it I didn't know. And so Nancy was really right, because nobody really knows what's in this bill. But the Anti-Injunction Act essentially says in taxes, you got to pay the tax, apply for the refund, and then sue over the refund in order to challenge the refund or even the underlying law. So here, what the question was is, do we have to wait until after 2014 when the mandate goes into effect? Now, our arguments are several. Number one, that this is not a tax, it's a penalty. Therefore, the Anti-Injunction Act does not apply outside of taxes. And I think that's a crucial argument, and that the court has to reach that question before even determining whether the Anti-Injunction Act applies. They can't apply it without first deciding whether this is a tax or a penalty, tax under the Taxing and Spending Clause or a penalty under the Commerce Clause. Obviously, it's a penalty under the Commerce Clause. That's how Congress passed it. We also said, however, that even if it were a tax, there's an exception to the Anti-Injunction Act, that even in those areas where the Anti-Injunction Act clearly applies, if there's no alternative remedy and you face irreparable harm, then the Anti-Injunction Act is not going to prohibit you from going to court. In this particular case, even if it were a tax, which it's not, but if it were, and it doesn't get paid until sometime after 2014, we would face irreparable harm and there would be no adequate remedy. Why? Because in 2010, 11, and 12, and 13, this law is going into effect. We see that. You don't need to be a constitutional attorney to figure that out, by virtue of the 1,000 plus employers that have already asked for a temporary waiver. Why would they ask for a temporary waiver if they're not being impacted by the law now, before the mandate comes into effect? They are feeling the burden of the law. It's kind of like the weight of the law is sinking in, settling down. People's behavior, their business, their decisions are being affected now. They're actually having to make significant financial expenditures now, and that's because of this law. They can't wait several years to challenge it, because there would be no remedy to the injury that they are experiencing today. So it's very clear that the Anti-Injunction Act doesn't apply to this case, no matter how you slice the pie. But even more so when the federal government says, we look at our own statute, and our own statute, the congressional intent is that it does not apply. Go ahead, court, and reach the merits, which is good news for us. meaning that we will have the first decision in the country on the merits of this case, and from there be the first ones likely to go to the United States Supreme Court.
You know, Matt, you've pointed out repeatedly that that Congress literally passed this as a penalty. There's no question about the use of the language. It's a real stretch to try to make it a tax in the first place. But if there's ever been a place for that exception to apply, we're not talking about the normal situation where the government's saying, wait and see if you get taxed, and if you get taxed, then we'll look at the refund and see if you're entitled to it, and then you get your right to sue then. We're looking at literally a train wreck. We know it's coming. The train wreck is unavoidable, and it's got consequences that are far-stretching through the entire U.S. economy.
Yeah, it's like the locomotive is pulling the train, and you're sitting in the train track. And the tax is at the very end. It's the caboose. It's the last thing to hit you. But you're being hit by the locomotive and, you know, a whole line of trailer cars that are being pulled by the locomotive. You're being injured now. You can't wait to say, let me get hit by the caboose before I can actually file suit and get my remedy here. That's what's happening with this. It's like a domino effect, and it is going into effect now. You can't wait for the last domino, i.e. the actual penalty to be imposed to file suit. You're being injured today, which is unlike, for example, an income tax or some other kind of tax where you're not injured until you actually pay the tax.
This one's very precise in the future. It's got a very knowable date. You know that it's going to happen. It's perfect for the exclusion. And you pointed out as well that with so many people filing for exemptions and being granted them in this case, they know up front what's going on. Everybody knows what's coming.
20% of which have been filed in Nancy Pelosi's district, by the way.
That's right.
Kind of an interesting, ironic fact, obviously, wouldn't you think?
It's fascinating on several levels, especially since when we spoke yesterday about the political ramifications of this, what's happened with the government's timing on this and Liberty Counsel's timing of filing it is it's forced the government into a very uncomfortable political situation with a fight that they've tried to carry on. They've been arguing tax all this time. Do you really want to announce a new tax going into a presidential election cycle?
Yeah, well, they don't. Obviously, it's a political quagmire for them. One of the interesting things that Nancy Pelosi said is we've got to pass the bill to find out what's in it. Well, she was really right. You know, I don't agree with her on many things, but I agree with her on that. I have been litigating this, reading things for a number of months, immersing myself into this case. It wasn't until just a short while ago that I read an amicus brief filed in the Florida case, and it was filed by 350 Indian tribes. And the interesting thing is that there is a federal law that gives the Indian tribes kind of a special federal statutory scheme for health care. And there's this board that oversees certain health care within the Indian tribes. Well, from 1999 to the present, for over a decade actually, they've been trying to put amendments into Congress to update and expand that law, to give them additional rights and benefits and privileges and so forth. And this Indian tribe brief says that they actually were able to get a committee hearing, and they one time got, in these 10-plus years, the bill to have a debate on one of the chamber floors, but not both chambers. So they never really got very far. Well, guess what happened? A paragraph was inserted into the ObamaCare statute 2 to 3 days before its passage in December of 2009. And it was just a little paragraph, and it refers to this other bill. This other bill is 291 pages. So you'd have to, this already is a 2,700-page bill. One paragraph now refers to this bill over here that's 291 pages that has never gotten any political traction for over a decade. Well, that's now part of Obamacare. And it gives all different kinds of benefits and so forth. It allows the Indian tribes to essentially establish their own Medicaid system so that they don't have to go through a typical Medicaid entitlement. The Indian tribes can basically put all of their people through their own discretion that they want to on Medicaid, and the federal government has to pay for it. So this is an incredible expansion of federal dollars being spent, assumed in one paragraph, referencing some other standalone bill that could not get any political traction on its own. But now it's part of Obamacare. Interesting revelation, but it's only one of many things that are lurking in this bill. The cost of this is astronomical, and no one really knows how far this will actually cost. How much is this little standalone bill that could never get any traction going to cost? Who knows? The fact of the matter is, if Obamacare is not struck down as unconstitutional, which I believe it will be, the United States government will become bankrupt because of this. It'll push us over the edge. Give us a call at Liberty Counsel, 1-800-671-1776. Help support this case by asking for our Patriots Handbook on American Liberty and my book, Take Back America. That's the book, Take Back America. You can go to lc.org. Support this case and Liberty Counsel through your prayers and through your regular financial commitment. Go to lc.org for more information.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.